Lordship sees what is there. Your Lordship means India the Indian pharmacopoeia, and there are each chemist has a booklet which shows products that are available in the market. Those products demonstrate what has been sold, various brands, the same product with various combinations. It's actually in India, or was it in India? Please note two things. I'll come to 56. One, this product A is approved in other jurisdictions. That's number one. Your Lordships asked me that question on the last occasion. Number one. And that is also a factor of distinction. My friend made an interesting point that it may be approved for population A, but it may not be necessarily good for population B. Nothing on the record to suggest any of this discussion, any of this factual correction. This FTC is not approved in the countries that my friend has said. This is not approved. I've got that news. Now, your Lordships will only see page 56, the judgment of the Delhi High Court.
No, Mr. Rauti, 1988.
Yes,
what is the material?
Yes,
apart from your name being mentioned in the list, what is the material?
Please just have two things. Like I said, the only thing I can show is
demonstrated even before the Supreme Court for the observations in para 37. Otherwise, you move to 38 then.
Very good. But may I just show your Lordships page 56 of the same paper book for a moment, which is the High Court's order.
Page 56.
The fact that, if your Lordship will just see the notification at page 55 for a moment. Yes, please. Yeah. This is the erstwhile notification. No, but this is what don't get into that. They're asking you a specific question. So your Lordship knows I first went through the scrutiny in 2016. The Kokate committee made recommendations. The Supreme Court says you are never meant to be sent to the Kokate committee because 21st September 1988 was the cutoff date. Now, the fact that 21st September 1988 is the cutoff date is because that concept arises thereafter. Now, please just note one thing. Please have the rules straight away, and please have 122E. First, please have part 10A, 122A. That is where that magic figure of 21,988 comes from. So there is an amendment to the rules whereby the introduction of part 10A comes into play.
122A.
Yes, your Lordship, just see part 10A, just above it. So part 10A, which is import or manufacture of a new drug for clinical trials or marketing. As my friend said, the regulatory process changes. So therefore, I was subjected to an erstwhile process where the central government gave an NOC to a state licensing authority to permit licensing for certain drugs. It is not my friend's case that this combination was not permitted to be licensed in the first instance. That's not their case.
That's my case. Unless there is material to show that this is approved pre-88, I can't accept that.
I'm so sorry. Then my friend should have banned me in 1988. But your Lordship is right. I still have to satisfy the aspect of efficacy. And that's why I said, I'm so sorry. If I was not licensed, I would have faced prosecution under the Drugs and Cosmetics.
No, it doesn't mean that if you were not banned in 88, they can't do it right.
No, absolutely not. Which is why the de novo consideration. But the principle is slightly different. And that's why I said, we are proceeding on the basis that the central government must ban. That principle
is proceeding on your assumption that the drug is actually licensed, it's been approved for the efficacy and safety.
But with respect,
we're not able to show that.
I'm so sorry. Let me step back, and that's why I said,
because see, as I'm pointing out, Mr. Doctor, your trust is, look, you cannot do this, take this strong measure of banning me because I have been in existence.
Yes.
So your existence is now being in doubt.
Yes.
You have existed.
Yes.
No doubt.
Yes.
But what is the material? How did you come into existence? What was the test on this particular drug?
So three principles.
Till the time you have been actually exercised, the government has exercised the power under 26.
So that's
the foundation of
answer that as a matter of law and as a matter of fact. I have my limitations, but I must answer that. As a matter of law, the fact that I had a license or somebody had a license and was in fact manufacturing this combination pre-88 is not a fact that is disputed. As a matter of fact, we'll come to whether legally it was permissible or not. We'll come to that for a moment. The fact that this product was in the market pre-21,988 is an admitted position. The Supreme Court notes this and carves me out. My friend doesn't raise an objection, number one. Number two, my friend treats me as a part of that list of 15 FDCs which are pre-21,988, which he is entitled to consider de novo as to the applicability of 26A and therefore applies 26A to me. So to that extent also, Manoj, the fact that I was in the market pre-1988 is not in dispute. Now, Manoj, my only answer to your Lordship's question, what was the material to demonstrate efficacy? Manoj, first, it's nearly 20 years, 30 years old. I'm not required to maintain it. The statutory authority having given me a license, the presumption is that I was, Manoj, compliant. The presumption. Actually, the parliamentary committee finds that perhaps some problems on the ground. It is not their case that my license that was granted to this combination or the approval that was granted to this combination was also procured by illegal means or whatever. No question mark specifically. But yes, the question today is this combination in today's day and age something that the central government would want in the market? And in exercise of this extraordinary power under 26A, will the central government be justified in banning the product? And the reason I'm emphasizing that word is, if your Lordships will note, the original iteration of section 26A said ban. The amended iteration introduces these three stipulations, which your Lordships will just permit me to go back to 26A. And please have that straight away. And your Lordships will recall the submission I made as a matter of legislative intent. A statute that was in its first amended iteration, determinative of, which granted a power to ban, that statutory power is diluted, and some guidance is given to suggest this. It says, first, the heading is modified, power of central government to regulate, restrict or prohibit, as opposed to just prohibit, manufacture, etc. of drug and cosmetic public interest and cosmetics in public interest, without prejudice to any other provision contained in this chapter, if the central government is satisfied that the use of any drug or cosmetic is likely to involve any risk to human beings or animals, or that any drug does not have the therapeutic value claimed or purported to be claimed for it, or contains ingredients and in such quantity for which there is no therapeutic justification, and that in the public interest it is necessary or expedient so to do, then that government may, by notification in the official gazette, please note, regulate, restrict, or prohibit the manufacture, sale, or distribution of such drug or cosmetic. I am here only challenging the decision of the central government to prohibit in the facts and circumstances. And I am cognizant of the limitations that I, as also your Lordships, have in our inability to sit in judgment over technical data. That is something I will never call upon your Lordships to do. The question is,
ultimately you are doing that also, that only.
No, Manoj, with respect.
Because they say that they issued this notification based upon the technical data.
Your Lordships will see that. That's why I said, Manoj, your Lordship asked me a very pointed question. What is the material to demonstrate efficacy? When I place that material, Manoj, that is not considered. In fact, in my case, in my specific case, Manoj, it was given, we sought time, we had to do a study, we asked for 6 months, we were given 3 months. We submit that. The committee did not have the benefit of it, the DTAD did. That's not considered.
No, the reply says it was considered.
Well, factually speaking, I'm sorry, my friend says that he sought time and he was given time. The committee did not give my friend any time.
No.
My friend has placed on record some data that he has, some trial that my friend says he has done. I don't know how and what permission my friend has got to conduct that trial. But that trial also seems to have gotten over sometime in October or August 2022. After the report has been submitted. So first and foremost, I'm really not sure how my friend conducts a trial without the permission for conducting a trial.
So you don't granted the permission for that?
No, my friend is not.
I'm so grateful.
Private trial.
Private trial, absolutely. And your Lordship therefore asked me, what material?
And what Mr. Rao, sorry, go on.
Sorry, sir. No, my friend has to either demonstrate that a clinical trial was warranted before my product would be in the market. Not his case.
Of course, it is the case that is how my
Hear my friend, because the difficulty with dealing with a situation where I am told you are out of the market and I have virtually nothing to play with is, Manoj, the fact that my friend concedes very fairly that the regulatory framework was grey. But today wants to apply something in black and white. Let him show the black and white first.
Yes, please.
So therefore, Manoj, that's why I said at the end of the day, it is like saying This, your lordship will just test why, on what basis I am sought to be ousted. Please have that. And that's why I said, I'm not calling upon your lordships to sit in judgment, but your lordships are entitled to examine the process. Please first have the order constituting the expert committee at page 217 of the paper.
But in, Mr. Rao, is it correct in 1995,
Yes, Mr.
the regulatory regime required the efficacy to be proved
Yes, Mr.
and somebody would have done it?
Absolutely.
Who was that entity who would have done it?
Because I must be candid, I don't. So in fact, that's some of the information that I asked for is exactly what your lordship is asking. It is slightly ancient data. I'm sure my friend will have that data, because otherwise he wouldn't have granted me that data.
Well, that document I've just handed over, in fact, Laborate, which is the petitioner, had submitted a representation. In that representation, Malad, I've just handed that over. In fact, it's also there in my compilation.
Yes.
But if your lordship will turn the first page, on the right, Malad, there's a column, Malad, on top. Malad, first page, or actually the second page, Malad.
This one, approval of similar FDC.
Yes, that. Yeah. Malad, show me the
Yes.
Malad, on the inside of the first page, Malad.
Yes.
Details of approval.
Yes, Malad. Details of approval, there's 2595 mentioned, Malad, right on top.
That's 10th March. The date is wrong. It's 10th March.
Yes, 2595.
2590.
Because in fact, yes, you can see this.
595.
Yes.
That's the date of the original approval that my friend has followed.
Just read it. What does it say? Please refer to letter 27. No objection to your marketing being published. Yes.
Because in fact, that date of 25 may also not be entirely, I don't know if it's accurate, because the CDSO chart says 10/3/95.
So that possibly is the letter issued to the company after 10/3/95. So that's the document, Malad, that they have placed on record. I don't have the record supporting this document. But obviously it's a part of the
Is that record available? Not.
Malad, we'll have to locate it. You'll have to locate it. Malad, we don't really know.
Perhaps not. And may I just show you
The only thing is, Malad, if the document, the representation that my friend has given, if your lordship will take that, go to the next page. Malad, approval of similar FTCs in the regulated markets. And if your lordship will take the next page, your lordship will see the approvals that my friend has placed on record. Your lordship will bear only one thing in mind. The ban is in respect of the combination codeine, 10 mg and chlorophenamine, 4 mg syrup. It is syrup. What your lordship will see, Malad, all the petitioners perhaps will show your lordship's approvals. They are either in the form of tablets or in the form of sustained release suspensions. Now the difference is this. When it is a syrup, Malad, it is used as an intoxicant. When it is a tablet or sustained release, it can't be used as an intoxicant. So what we have banned, apart from other reasons, because ultimately, Malad, in terms of literature also, this is more of a placebo. What we have banned is the syrup combination. If my friend want to manufacture it differently, they must apply and take the permission for it differently. Your lordship will see the notification. The notification says specifically syrup. And Malad, this is becoming rampantly abused all over. Codeine, Malad.
Because then they should ban codeine.
No.
Not a combination of.
Codeine is not sold as a drug, sir.
I'm so sorry, Malad, my friend should just verify that. My friend is absolutely right. If something is abused, it is codeine. This is something that is a combination of an antitussive and an antihistamine.
We are talking about a syrup.
Yes, we are.
So as a tablet, it may be approved in different. In fact, we've got this list also. Even these are not approved in the US.
Yes, my product is approved as a syrup. Oral suspension.
There you go.
No, US also. This is here.
So in the first page itself, after the index,
आप एक्स्ट्रा दे दो.
It's only one cup. Well, page one itself, in the inside page of the index. These are the ones that have been mentioned in the representation given by laboratory, and the details that are mentioned are given there. So none of them, the one that is a syrup is item 6. But that is not in the combination that your lordships are looking at.
It's in a tablet form.
Well, item 6 is a syrup. Codeine phosphate versus promethazine and hydroquinone. That is not the combination that you're also looking at. That's a different one. That's a different combination. And the others are suspension, extended release, etc., etc.
In fact, my friend makes my life a lot easier. A slight tweak to a combination can alter its efficacy.
Absolutely.
And therefore, your lordships will have to be shown that each of these products has been tested with reference to these specific combinations. And therefore, I'm asking myself, and that's the point I was making. A regulator who says, I will not allow you to sell this combination because it is harmful, he has to tell me that this combination is harmful.
No. You have to take permission from the regulator saying that this by
I'm grateful. Your lordship is right.
all documents and research material, drug
Please,
trial, whatever.
Your lordship is absolutely right.
Effectively,
Please see what is approved. Your lordship will just test that the same company.
if petitioners want me to conduct a trial and show that.
No, I'm so sorry. That's not even what I'm calling my friend to do. I'm so sorry. I'm asking my friend to do his job, but I'll show your lordship what the job is. It is not for him to conduct a trial. Please permit me just to show your lordships what was approved. Please have their document, not mine, page 84 of my additional documents, Annexure P16. And this may perhaps also address a question that your lordship put with regard to material, because your lordship has that? Page number 84 if your lordship has. This is Annexure P16. And the heading says it all.
Please wait. Yes.
But Annexure P16 is a list of fixed dose combinations approved by the Drug Controller General of India since 1961 to 31st December 2019. So, the fact that the pharmaceutical industry has combined different products of varying strengths is something that is not unknown to science or to the drug controller. Now, please note, your lordship sees the first approval is January 61. Now, there are two ways of verifying that this approval is kosher. One, that there is an approval. Number two, that my friend says that approval was given in accordance with a fixed study. But that does not mean that my friend cannot ask for a revised study 10 years down the line, 20 years down the line. Antibiotics, for instance, because your lordship knows now resistance. So therefore, we find ways to try and limit use, etc., etc. Those are all regulatory powers. I figure in that list, at page 175, at serial number 1217. And I'm not approved as a tablet. It's a syrup.
Serial number?
1217. And please contrast it with 1216 and 1218. And also, please see, so 1216 is an uncoated dispersible tablet. 1217, that is me, each 5 ml contains chlorpheniramine maleate at 4 mg, codeine phosphate at 10 mg, for dry cough. The date of approval, which is the last column, is 10th of March 1995. Now, I ask myself today, in 2023, can I be called upon to say, explain the basis on which this approval was granted in the first instance as a matter of law? I'll take that, the presumption is all official acts have been done properly. This has never been challenged. And on the contrary, we have all been given licenses to manufacture and sell pursuant to this approval and prior to that also. But I must satisfy your lordship's conscience that when I calling upon your lordships to interfere with a ban, I am not calling upon your lordships to, let's say, they can't regulate. The Drugs and Cosmetics Act is the power to regulate. That is the reasonable restriction upon me under Article 19. The rules, Manoj, which confer delegated authority, please have section 33. This is an interesting place. Manoj, please just see the manner in which the legislature carves out certain responsibilities for a minute. Section 33 of the Drugs and Cosmetics Act. The central government may, after consultation with or on the recommendation of, so it doesn't necessarily have to be a unilateral act, it could come from the authority which is more in tune with what's happening on the ground. The board, which is constituted under section 5, and after previous publication by notification in the official gazette, make rules for the purposes of giving effect to the provisions of this chapter, provided that the consultation with the board may be dispensed with if the central government is of the opinion that circumstances have arisen which render it necessary to make rules without such consultation. But in such a case, the board shall be consulted within 6 months of the making of the rules, and the central government shall take into consideration any suggestions which the board may make in relation to the amendment of the said rules. Now, please note, after the regulatory powers minutes, this is not one of those rules that is placed before Parliament. Please see that. This is purely administrative, delegated legislation. Now, the reason the legislature in its wisdom confers this power is because there are multiple authorities who are expected to exercise their individual checks and balance roles in the framework. Now, unfortunately, what I will demonstrate from the record, and which is why what is conspicuous by its absence in this case is the record, that each of these authorities has failed your lordship and the statute, and as a consequence has impinged my rights and has gone beyond what was reasonable as a matter of law, and therefore, the aspect of proportionality which your lordships repeatedly emphasize when testing conduct of authorities comes into play. And that's why I said, not for a minute am I suggesting that I cannot be regulated. I cannot survive if I'm not regulated. But is the answer a ban? And is a ban justified in the facts of this case in light of what has fallen in the legislative, the legal history, the litigative history of this one case, and of course, the view that your lordships have taken in other matters. But stepping away, as a jurisdiction, do we want to send a message that my response to something that I don't like
Do you have 1995 report with you?
Well, I've already asked for that. We are going to look for it. I follow. One aspect, if your lordship will take for a moment, the representations that had been received by us.
We want to know on what basis this letter was issued.
I agree.
This 2-5 to 1995.
In fact, my lord, the entire genesis, when your lordship will notice the first few paragraphs in Pfizer, the entire genesis was the fact that these approvals seem to have been given, a lot of these approvals seem to have been given in ways that were not exactly.
So we would like to know whether proper study was done, whether research was done,
I follow.
or the approvals were given mechanically.
I follow. Your lordships are right about that.
Because if the government was at fault in 1995, then it's a different issue altogether.
That's right.
Because we are concerned with the public safety, the
Yes.
health issue. So if how was these licenses in 1995?
And your lordships are right. As an officer of your lordship's court, I must say so, that if we have been amiss there,
That's right.
then we should also be hauled up for that. Some, your lordship's observations may not be entirely inappropriate. So I agree with your lordships there. But that perhaps will be even.
Take for you to trace this.
I'm sorry,
How much time will it take for you to trace the report?
Well, your lordship will list it after the break. I will locate it. I can locate what I can. But your lordships are right. that would be important.
So we'll continue with this case at 2:15.
Oh, I'm sorry.
How much time you need?
2 weeks. 2 weeks. I meant the holiday. Just one aspect, Lord. Your Lordship will take in the compilation, in the documents that are given, there's a representation by Shreya Life Sciences in the pen drive.
Pen drive, they will not be able to do.
Very well. Your Lordship will take this forward.
It's on the. It's on the.
So that they said, no, that they said deal exam. So that is.
Your Lordship will see that. वही दे दो. Well, now, in terms of the information sought,
Yes.
we are asked specifically for the safety and efficacy data. Your Lordship will see the first line there. Right there on safety and efficacy data. They say very clearly and honestly that there is no published study on the safety and efficacy of this FDC. Very clearly.
This is for, this is the form.
This is a representation submitted by one of the manufacturers, one of the petitioners.
That is
Your Lordship will see that line there, right on top.
That's it. Please take that against me. And just to assist, my friend very fairly hands over a document. In the United States, the FDA approves the same combination with a higher strong dosage. Well, it's with a prescription. That's all. That's the
in
point
syrup
I'm making.
form or in a tablet form?
Well, this is a syrup. Oral syrup. That's the point I'm making.
That's been discontinued. That's the reason why the
I'm
annexed
so sorry,
letter.
marketing status is not discontinued. Prescription. This is prescription. The other ones have been discontinued. That's the point.
That's what I was saying. Look, this is not the combination.
No, it is the
It's
combination.
not the combination. It's promethazine.
It's not the combination involved in your case. This is what he's saying.
Sure, Your Lordship. That my combination is approved in the US and it works. But anyway, that cannot be the ground on the basis of which I want to sell in India. Because we are in the business of make in India today.
Shri Rajeshwar Rao, learned senior counsel for the petitioner. Shri Kirtiman Singh, learned ASG for the respondents. Learned counsel for the central government has brought to the notice of this court letter dated 2/5/1995, by which permission was granted for the fixed dose combination by Government of India. Point. This court would like to know on what basis the aforesaid permission was granted and what was the materials submitted by the manufacturer to the Government of India / competent authority. Shri Kirtiman Singh prays for 2 weeks' time in the matter. Is granted 2 weeks' time. Lists the matter after 2 weeks.
10th November. 10th November.
Your Lordship said directed my friend to file the relevant record. He has filed 4 volumes. I take it that is the relevant record.
Pen drive is a security risk, so they will not be able to take the pen drive.
We have not. Because if we can't trust the government, then who can?
Can it be emailed to the court? Yes.
We have not been given this pen drive. She copies to us.
Mr. Kirtiman Singh prays for permission to file certain documents. He is permitted to do so with a copy to the other side.
I'm grateful. Yes.
But that's the record that we lost from the record.
That's right. That's right.
Yes, please. Next, please.
Most grateful.
The witness, and tomorrow is my last and final opportunity for responding evidence. On 1st of August, my application under 1310 was dismissed. Your Lordship, for the first application which was dismissed, again, I had to come to your Lordships, and your Lordships